You got
Court reporter, it's just a minute.
Right.
Well, it'll take us.
You tell
to
me
get
when,
everything.
you tell me when you're ready. And I'll ram the gavel.
I sound like thanks.
Oh, she look, Eve was drinking this morning on the job.
Trying to reboot that thing. I don't know what that means. I just heard people saying that.
Anybody ever ask you if you need to be rebooted?
Yeah, I thought when you rebooted one, you just stomped on the damn thing.
Well, it's kind of the same thing.
You talking about my computer or my body part?
Yeah, I hear the people next door.
I'll start ramming you.
It's surprising the walls are that thin.
Yeah, you'd think they'd be a little more safe.
This is a state facility.
Well, that's true.
Did you tell them they could stay till noon?
Yeah, Judge Williams, I was in Vietnam. You'd be flying around the helicopter, you look over at your buddy and say, how's it feel knowing you're riding in the helicopter that was built by the lowest bidder?
Oh, wow, look at all of those programs.
Our stuff is like fancier than most.
We'll get started just as soon as we get our court reporter up to speed. She's having a little problem with rebooting her computer.
I guess it's the location, reckon.
They've got a real slow, it's a state facility. They've got a slow internet connection here, real slow.
Well, no, I didn't have a problem.
Oh, I'm having mine is just.
I didn't have any problem with mine either.
Yeah, I know you don't.
No problem here.
I told the girls, what they did was at breakfast, because I put my check on yours, because we were obviously together, and Robin said, well, I guess yours is worthwhile. I said, I probably was close to banking while he's got him his commission.
Oh, okay.
Julie said, you're probably the closest thing he wants to us.
Yeah,
Sure of that.
I will.
2 days a month's about all he wants, somebody falls in him.
That's enough.
Oh, give me some more hot water. That's impressive.
You ready?
Ready?
Okay, we're good?
Yep, we're good. I'd like to call the second day of this regularly scheduled Tennessee Real Estate Commission meeting back into session. Once again, I want to remind all of you to turn your cell phones to off or silent or vibrate or whatever. But we have a hearing this morning, and at this time, I think Judge Williams, we have a judge from the state, Judge Madeline Williams, and I'm going to turn things over to you, Judge Williams.
All right. Thank you, sir. Today is Friday, May 10th, the year 2013. This is a hearing being conducted by the Tennessee Real Estate Commission. Today's commission is chaired by Mr. Bear Stevenson and will consider the case of Mr. Adrian Bond, license number 299968, docket number 12.18-120574A. Assistant General Counsel Robin L. Ryan represents the state in this matter. Mr. Bond is present today but is without legal counsel. Mr. Bond, are you aware of your right to an attorney, and are you electing to waive that right and to represent yourself in this matter?
Yes, I am.
All right. My name is Madeline B. Williams, and I've been assigned by the Secretary of State to serve at this hearing as administrative judge. I'll make rulings regarding the order of proceedings, the admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but I will not participate in the findings of fact or the ultimate decision of this board. Those decisions will be made by the board members, rather the commission members. At this time, I would now ask the commission members to introduce themselves for the record, starting with the gentleman to my immediate left.
Isaac Northern.
Janet DeChara.
Bear Stevenson.
Michelle Haynes.
Wendell Alexander.
David Flickcroft.
Thank you. And yes, there is a quorum of the commission present today. Members of the commission are reminded that during the time this hearing is being conducted, no discussion of this case should take place between commission members, witnesses, attorneys, or other persons unless all parties are present. This commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires that all commission discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or remanded if appealed. Commission members, you should not draw any conclusions until all of the proof has been submitted. Please listen to all of the proof with an open mind. I would ask the state at this time to distribute the notice of hearing and copies of the law and rules at this time. Before going further, I would remind members of the commission that the law requires that you disclose on the record any outside knowledge of this case, any communications, written, verbal, or otherwise, from any of the parties concerning this case. I would invite the commission members to look at the notice of hearing to see whether or not you have any conflict of interest with serving today.
Your Honor, there is one matter. I do not have a conflict of interest. However, I do have a prior engagement, and I'm going to have to leave at 11 o'clock today. I've talked it over with the chairman, and the board will still have a quorum. So I just wanted to make you aware of that.
Okay. All right. Thank you for noting that. We might be through by 11. I don't know. It's hard to determine. Does anyone have any conflict or outside knowledge to disclose? Okay.
No.
All right. During the course of this hearing, there will be an opportunity for each of you to ask questions of each witness that testifies under oath. Please use your questions as opportunities to gain clarifications of the facts that you feel would assist you in reaching a decision in this matter. However, you must reserve any expression of opinion you may have to that portion of the hearing that's set aside for the board's deliberations after all of the proof in this matter has been heard. The pre-hearing technical record in the Adrian Bond matter includes the following. March 21, 2013, notice of hearing and charges. March 22, 2013, my opening letter. April 3rd, 2013, respondent's copy of the opening letter was returned. Envelope was addressed to Michael Brody. The opening letter was remailed to Mr. Bond. April 30th, 2013, the state's witness and exhibit list. Let me ask both parties, are there other documents or pleadings that have been filed that I did not list?
None from me, Your Honor.
And Mr. Bond?
No.
All right. Then I'll enter the documents I just mentioned as a technical record to date. At this time, I'm going to swear in all the witnesses who are going to testify. Would those of you who intend to testify, please raise your right hand?
I intend to call Mr. Bond. He should raise his right hand.
Right. There appear to be only two witnesses then.
That's correct.
All right. Let me ask both of the two of you. Do you swear or affirm that the testimony that you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, I do.
All right, the two witnesses are now sworn. Let me ask both parties, are there any witnesses who are going to join us later? Are there any witnesses who are going to testify by telephone conference call?
None from the state.
None.
Okay, so then so now all the witnesses have been sworn in. Does either party desire the rule of sequestration?
No, Your Honor, my witness is the director for the state and is a party, so, and
Okay, so then there's no one to exclude. Are there any preliminary motions or stipulations?
no, Your Honor.
Opportunity for opening statements.
Please.
Please proceed.
Thank you. Mr. Bond is a licensee, and he applied for his broker's license in 2012, which brings us to the issue before you today. Proof will show that he was first licensed in 2005 and again in 2008 after expiration. But the proof will further show that in 2003, Mr. Bond did receive a disciplinary action against him from the Division of Securities. And the document from the Division of Securities state that as a part of that discipline, he was banned from applying for any license issued to the Department of Commerce and Insurance and was assessed a civil penalty of $20,000, and his registration as an agent under the Security Division was denied. The date of this consent order was September 2nd, 2004, and there appears to be a signature that is very much the same as Mr. Bond's on that document. We will show that in his application for a license with this division in 2005, he did not reveal that a complaint had been filed against him, as required by the application, and in fact answered no to that question, and answered further no if he had ever been refused a license or had any complaint filed against him by any regulatory agency. Proof will show that again in 2008, after his license expired, he was again required to file answers to the same questions on his application, and again he lied and answered no to the same questions. And finally, when he applied for his broker license in 2011, Again, he answered no, and proof will show that, again, that was a lie on his application for the exam. In a response from Mr. Bond, filed after the 10-day requirement under the law, well after that, he disputes the securities document by saying that it is not his signature. And he had in his answer, and which you will be able to read, arguments about why and what happened in the securities, but he did not address the issue of what we have before you today is, was there any complaint filed against him by any other agency? Has there ever been, and has he ever been disciplined? We are asking today that this commission consider the serious nature of his continuous lying manner and cover-ups, and that this commission consider revoking his license, issue him a civil penalty, and require him to pay all the court costs.
Thank you for your opening statement. Mr. Bond, would you like to make an opening statement?
Yes. In September of '04, in which the consent order was apparently signed by me, the situation surrounding those circumstances, in October of '03 is when I left the previous firm. It was under the name of Prudential Securities / Wachovia Securities.
Your Honor, if I might, if he's going to testify, or he could put his testimony on later. This is just opening statements about the facts before.
Let me clarify. An opening statement is supposed to be a summary of your position, not the full testimony that you're going to give when you're called as a witness. And sometimes that distinction is difficult for persons who are representing themselves. Because it sounds like you're getting ready to testify about all the various merits of the contrary to the state's position. So is there a summary statement that you can make?
Okay. Well, the summary statement is that I never signed the consent order, which is at stake, that was dated September 2004, which stated that that I could not apply for a license through the Tennessee Department of Commerce and Insurance.
All right. Thank you for your opening statement. The state's witnesses will testify first because the state has the burden of proof in this matter.
Over there.
It's okay.
I would call Eve Maxwell. Could you please state your full name for the record?
Eve M. Maxwell.
And Ms. Maxwell, what is your position with the state of Tennessee?
I'm the Executive Director of the Tennessee Real Estate Commission.
And as the Executive Director, are you familiar with the licensing files and the discipline files and complaint files of Mr. Bond?
Yes, I am.
When was he first licensed?
Mr. Bond, who holds license number 299968, was first licensed as an affiliate broker on August the 3rd of 2005.
And when was does he have a current license now at the same license number as the 2005?
Yes, he has the same license number that he had in 2005. Excuse me. He was licensed, his license expired. He retested and reapplied. So he went through the licensing procedure again and was issued the same license number, but another license on 3/26 of 2008 as an affiliate broker as well.
Has he ever applied to also be a principal broker?
He applied, he took and passed the broker exam and applied to become a broker, and then ultimately the principal broker, but he applied to become a broker on April the 5th of 2012.
And for each time, was he required to fill out a separate and distinct application?
Yes, he was. So there are 3 different applications that he filled out for those 3 times.
Let's start with the 2005 application. What information is required of the applicant when they file? Are there specific questions they must answer?
There are specific screening questions that are they're asked twice. Once they're asked when you sign up for the exams. We have a state and a national exam, so they're asked once when you sign up for them, and then you're asked to confirm, or you can change those answers if you discover that they're wrong when you get to the exam itself. So there's a reconfirmation, as it were, of the answers to those questions, and there are 6 questions.
And could you read all 6 questions, please?
Yes, the first question is, do you now hold or have you ever held a real estate or timeshare license in Tennessee or any other state? Number 2, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Do not include motor vehicle license. 3, have you ever been refused or had a real estate or timeshare salesperson license revoked, suspended, reprimanded, or fined? Number 4, have you ever had a complaint filed against you with any regulatory agency or with any court? 5, have you ever pled guilty, pled nolo contendere, or have been convicted of any criminal offense? Do not include traffic violations. And number 6, are you at least 18 years of age?
Now, the pertinent questions in this particular matter are whether or not there's any been discipline filed or a complaint filed, and I would assume the question about whether or not he's ever been disciplined. In 2005, how did Mr. Bond respond to the question about whether he's had any complaint filed against him by any other regulatory board or agency?
That would be question number 4,
Oh, is it? Okay.
I believe, that says, have you ever had a complaint filed against you with any regulatory agency or with any court? And the answer was that Mr. Bond gave was no to number 4.
And that was in 2005?
That was in 2005.
And what was the answer he gave? Has he ever been disciplined by any regulatory board or agency?
Have you ever been, that's number 2, I believe. Mm-hmm. Have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Do not include motor vehicle license. And the answer that Mr. Bond gave in 2005 to number 2 was no.
Would you please look at the 2008 application?
Okay.
In 2008, for the same questions, if you'd read them and answer, and please say what Mr. Bond replied.
Do you just want me to read those 2
Yes.
questions? Number 2, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Do not include motor vehicle license. And the answer in 2008 that Mr. Bond gave was no. Number 4, have you ever had a complaint filed against you with any regulatory agency or with any court? And the answer Mr. Bond gave in 2008 was no.
Okay. And would you look at the most recent application from Mr. Bond and the date of that application?
The exam date of this application, which would have been the reconfirmation of the answers, was 2/22/2012.
And the questions and answers, please?
The question number 2, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Do not include motor vehicle license. The answer that Mr. Bond gave was no. Number 4, have you ever had a complaint filed against you with any regulatory agency or with any court? And the answer Mr. Bond gave in 2012 was no.
Now, in this particular case, when was the security information judgment provided to the state of Tennessee?
It was provided to the state of Tennessee.
I'm sorry, I should have clarified that. It's provided to the Tennessee Real Estate Commission Division, State of Tennessee.
The Tennessee Real Estate Commission received this notice of this complaint on 3/18/2012. That's the fax date at the top.
And what was included in that?
Included in that was a cover sheet that said, "Attention, Ms. Fowler," who is one of the licensing techs. licensing department / Tennessee Real Estate Commission. And then a copy of a consent order that's titled Before the Commissioner of Commerce and Insurance of the State of Tennessee at Nashville, Tennessee Securities Division Petitioner versus Adrian Alley Bond Respondent, order number 04-015, and it's a consent order that is 17 pages, I believe 17 pages, and it's dated September the 2nd of 2004, signed, well, the signatures on it are Paula A. Flowers, Daphne D. Smith, Michelle K. Elliott, representing the state, and Adrian Alley Bond.
And as a result of getting the application, what did your department do?
As a result of receiving this application,
the judgment, I'm sorry.
right, we talked to the chief legal counsel, Mr. Wayne Pugh, and he advised us to open a complaint and to not approve the license for a broker application.
Was a complaint then opened against Mr. Bond?
A complaint was opened against Mr. Bond.
And did he file a response to that complaint?
He did not file a response immediately.
What does the law provide about when you must file a response to a complaint?
It must be filed within 10 days after receipt of the complaint.
Okay, and that's a provision of the...
Of the Broker Act.
Of the Broker Act.
Correct.
Did Mr. Bond file a response within 10 days?
No, he did not file a response within 10 days.
And when was the complaint opened?
The complaint was open on and sent for response on 4/10 of 2012.
And when was a response filed by Mr. Bond?
We received a letter from Mr. Bond on August the 15th of 2012.
And in that letter, does Mr. Bond address why he'd never bothered to tell the TREC or answer correctly the answer about whether or not any complaint had been filed against him?
He doesn't really address that issue.
Would you read the letter from Mr. Bond, please?
The letter is that TREC received the letter on August the 15th of 2012. The letter was dated August the 3rd of 2012. It was addressed to Mr. Connell House.
And who is Connell House?
He is our complaint coordinator.
Okay.
State of Tennessee, Tennessee Real Estate Commission, 500 James Robertson Parkway, Nashville, Tennessee, 37243. Ray, complaint filed against Adrian Bond. This is in response to the complaint that has been filed against me for falsification of licensure applications. After reviewing the records that was enclosed with the packet, I have information that contradicts those statements. First of all, I left Prudential Securities in October of 2003 of my own will because of a new business venture that I had started, and never sought to reinstate my securities license anywhere since I was permanently leaving the business due to the level of stress that was inherently tied to the business. And after medical visits, it was determined that my high blood pressure was directly related to the profession I was involved in. At the time I left my Prudential, I had over 500 clients, and so the option of returning to the business was never in consideration. I never applied to have my license remain active even after I left Prudential. I was later told through counsel that approximately 8 former clients who had helped with my outside business venture get started, that they complained of receiving their initial money that they contributed back within the contracted time frame, in which I vehemently refuted. Each one of the former clients received their initial deposit along with any contracted profits associated with the business. Some of the payments were made after the initial time frame is scheduled, which led to the initial allegations, but all were personally compensated, and I completely disagreed with the findings, in which most of all of the allegations were falsified in order to receive their initial seed money. Through counsel, I disputed the findings and never agreed to sign the consent order as prescribed to my attorney at that time. Part of the reasoning was at the time of the consent order in September of 2004, all of the former clients' business partners had been properly paid as contracted, and that I disagreed with the numerous statements in their former client's statements, so therefore I never signed that consent order as stated. I never met with anyone on September the 2nd of 2004 to sign that document, and not even sure where that signature was derived on that document. The signature looks different from my personal signature, but I'm certain that I was not present to sign that form. Since I've had my real estate license since 2005, I've never had a complaint with any of the 300-plus clients that I've dealt with. The previous allegations that I had when I was a financial advisor were with disgruntled business partners who were anxious in fulfilling the terms of that agreement with that past business venture. And although a couple of months behind the anticipated completion date, all of those people mentioned were paid in completion. Those allegations were brought after I left Prudential due to stress-induced medical conditions and after I left that industry with no intentions of ever going back. So after I was questioned by the state, my counsel advised me not to sign the consent order, and I never went back to Nashville to do so. When I filled out the applications for TREC, I never thought that I was subject to answering yes to any of the following questions. I have further information to convey as it relates to me having an active real estate license that I can relate in person if necessary.
May I approach the witness, Your Honor?
Yes, you may.
Is this the same letter that we're just speaking of?
Yes, ours has the date stamped on it.
May I have a copy of this document presented to the commission as part of my exhibits?
Yes, you may.
In that letter, anywhere except for that last statement about never thought he had to respond, does he say why he responded no when indeed there was a complaint filed against him?
No, he did not.
Okay. Now, as a result of the document from securities, you opened a complaint, is that correct?
That is correct.
And may I approach the witness?
Yes, you may.
Could you identify that, please, for the record?
This is the complaint that was opened by the Tennessee Real Estate Commission.
And included in that complaint are what documents?
I'm included in the complaint the application that for broker dated 2/22/2012 when the exam was taken, in which Mr. Bond answered question 2 and question 4, no.
Okay.
And then there's the fact sheet that Mr. Bond had covering up the facts which he sent, which had included some information about his application. And there's a letter from Mr. Bond addressed to the Sir or Madam at the Tennessee Real Estate Commission that says I've enclosed the forms for my Tennessee broker approval. I completed my class today and have put the actual document in the mail to you via FedEx. Do you want me to read the rest of that? Okay. And then there's the Tennessee broker exam application, which is a part of the exam pass-fail application. Mm-hmm. And that likewise has the question, have you ever had a complaint filed against you with any regulatory agency or with any court, to which he answered no, and there's a copy of that. There's the Tennessee Affiliate Broker Candidate Pre-License Education Verification. There's a copy of the 2008 application for affiliate broker, which was a retest and reapply, to which Mr. Bond answered no for questions 2 and 4. And there's then both pages of that application. And then there's the application from 2005 for affiliate broker, and the information where he answered the questions no, 2, and 4. And then there is a copy of the consent order between the Tennessee Securities Division petitioner Adrian Alley Bond respondent, order number 04015, that appears that was dated and entered on the 2nd of September 2004, and appears to be signed by Mr. Bond, Ms. Flowers, Daphne Smith, and Michelle Elliott.
And is this the copy of what was sent to Mr. Bond for his response?
Yes, it was.
Okay. And that response wasn't until August, is that right?
August the 15th, I believe. yes.
And you had sent it to him, like you had said earlier, I think, in March, is that correct?
Did
For
we
his-
send the complaint?
Yes.
The complaint was open 4/10 of 12.
Okay, so it would have been sent in 4/10 of 12.
Correct.
Okay. Your Honor, may I have the copy of the complaint that was filed, presented to the commission for their review?
Yes, you may.
Thank you. Ms. Maxwell, when you look at Mr. Bond's record and his licensing period, does he have any other disciplinary actions on his record?
He doesn't have any other disciplinary action. He was reinstated in July the 20th of 2010, which is, his license had expired, so he had to sign a reinstatement order and pay a fee to be reinstated, but not disciplinary action that was handed down by the commission.
In anywhere in the applications, are there any requirement to reveal if you had a license with any other agency, or is it just whether or not you've had that license revoked or disciplined?
If you had a real estate or a timeshare license in Tennessee or any other state, that has to be revealed. The only other instance in which you would have to reveal a license is if you've ever been refused or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government. And then if you ever had a complaint filed against you with any regulatory agency, by virtue of that, you would be disclosing the license.
So the license, at least with the Department of Securities, is something that should have been revealed by, at least by the action of the disciplinary action.
That is correct.
Okay. And I have nothing further for this witness at the moment.
All right. Did you wish the two documents to become Exhibit 1
Oh, please,
and
I would
Exhibit
like,
2?
yes, please, Exhibit 1 and Exhibit 2.
All right. Any objection to Mr. Bond to the documents? All right. Then the first one becomes Exhibit 1, and then the complaint becomes Exhibit 2 at this time.
Thank you.
Cross-examination. Mr. Bond, your first question for the witness.
Okay. Could you explain the process that the Tennessee Real Estate Commission goes when reviewing applications for an applicant?
Just any, whether you're
Yes.
a broker or affiliate broker?
Yes, affiliate.
I mean, differs just a little bit.
Okay.
For the affiliate broker, the individual has to have 90 hours of pre-license education. 60 can be taken before the exam, and then the other 30 has to be taken before licensure. Once the individual submits an application and they take the exam, and when they finish the exam, if they pass, they're issued a blue security paper like this, and that becomes the application for affiliate broker. And on that application, it has the screening questions that I read earlier, and it indicates whether the person passed or failed and when they took the exam. And then you have a place to put the firm name and the principal broker, because the Tennessee Broker Act requires that everyone affiliate with a principal broker and a firm, both licensed in Tennessee. So then once that's filled out, the individual takes this information and sends it to the Tennessee Real Estate Commission with the supporting documentation, which would be proof of high school graduation and proof that you took the course for new affiliates, because the pre-license course you would have already had certified, and any other documents, like if you had a name change, any other documents that might be required. That is sent in with the application fee, which at the time you applied was $130. It goes to the cashier's office. The cashier's office gets it, actually goes to the mailroom. The mailroom opens it, takes it to the cashier's office. The cashier's office processes the checks and notes that there was a payment on a file, or opens up a new file if it was a new applicant. And then all the documents at that point, once it's finished being logged in at the cashier's office, are delivered to the Tennessee Real Estate Commission. Once at the Tennessee Real Estate Commission, we review all the documentation to make sure it complies with those requirements under the Broker Act, and make sure the person has errors and omissions insurance. And that is reviewed by one person, and if there's a deficiency, you'll get a letter that says, the individual will be sent a letter that says, you know, we're missing, and there's a list of items, and you'll get a check mark on whatever you're missing. And if there's not a deficiency, you know, if there's not missing any documents, one person looks at it, and then if they say it's okay, then it goes to another person who reviews it for another time to make sure that everything's in order, and then it's approved. And so then the license itself is generated out of the data marketing processing part of the state, and hopefully is received by the licensee at the firm at which the licensee is affiliated. And so if, in fact, along the way, like someone has answered one of the questions, the screening questions, yes, then the person has to fill out an application for predetermination, which is reviewed by, I review it, and then the staff attorney reviews that to make a decision whether or not a person would have to appear before the commission.
And the Tennessee Real Estate Commission does fall under the Tennessee Department of Commerce and Insurance.
Yes, it does.
Okay. So when a real estate for an affiliate broker applies, is there a cross-reference with the Tennessee Department of Commerce and Insurance to ensure that this person is at least eligible for an application?
No, there's not. We rely upon the individual applying to answer the questions fully and completely.
So in the event that someone is technically barred from applying for a license through the Tennessee Department of Commerce and Insurance, there wouldn't be anything to come up to disallow that affiliate broker?
No, there would not. No, there would not. It doesn't cross over. As I say, we rely on the person to answer the questions.
Okay. And so when a person applies for a principal broker, does the same thing, does the same process work as well with the affiliate broker? How was?
The broker is a little bit different in that there are pre-requirements before you can even test for broker. So that the broker, you file an application with us initially before you even are certified to take the exam, and you have to have had 120 hours of education. You have to have had 3 years of active experience, licensure as an affiliate broker, and then you have to be 18. You have to show that you've taken a 30-hour office broker management course, and then once those pre-qualifications are met that are required in the statute, then we at the Tennessee Real Estate Commission will certify you to PSI, who's our current test administrator, to test. And then once the individual tests and passes, once again, they're issued a blue sheet of paper that comes into us that shows that you passed the exam and the date that it was passed. And it likewise has the screening questions on there.
Okay. At the time of February 22nd, 2012, for the Tennessee broker examination application, number 13 states that the Tennessee Real Estate received, was notified of a respondent's consent order dated September 2nd, 2004 with the Tennessee Securities Division of the Department of Commerce.
What are you reading?
This number 13.
I was looking at the notice of hearing.
Oh, okay, okay. Sorry, I didn't know what you were reading that from.
And it states that you all have received that order. The order didn't come up at the affiliate broker, but it came up at the time of the principal broker, correct?
The order, a copy of the order
Right.
Came into the the Tennessee Real Estate Commission office by fax on 3/18 of 2012.
Okay, and could you explain how that came about?
You know, I don't know why. I mean, I can only tell you that it came in on 3/18/2012 and the number from which it was faxed. And it didn't, it had a cover page that says, "Attention, Ms. Fowler, Licensing Department / Tennessee Real Estate Commission." And included behind that was the order. And that's what was sent to us. And so it did not come in with an identifying person's name on it.
So at the time of 2005, at the initial affiliate broker application, that order never came in?
No, it did not. And as I say, I don't, Ms. Fowler, this just came into her, and then she brought it to me.
Also, in March 8th, when at the time of when the first license expired, it didn't come in March of 08 either?
No, and I mean, I can tell you the fax number. As I said, I don't know what prompted someone to send this in this time.
Okay, well, that's all the questions.
All right.
Do
you have any redirects?
I do have a
for the
couple
witness?
redirects. Thank you. On the applications themselves, is there a place for him or an applicant to sign and say, "I verify that all information I gave is true and correct"? Do they swear or somehow make that statement?
Well, at the bottom of the application, it says, "Failure to disclose any required information is grounds for denial or revocation of a license."
Mm-hmm.
And so that's written at the bottom at the bottom of the questions prior to where the signature goes.
Okay, if you would look, please, also on the PSI examination services documentation.
Uh-huh.
And on the PSI examination services, this would be page 2 on the screening questions. This is in a part of the complaint.
Oh, in the complaint, okay.
Mhm.
What, are you on the broker?
I'm on the PSI examination document dated 7/19 of 05.
Okay.
Is there a place for a signature of an applicant?
Yes.
And what does it say?
I hereby certify that the information indicated above is true and accurate, and the information above are the screening questions that we referred to earlier.
To which he answered no.
Correct.
Okay. If you would also look at the first page of the complaint, it's dated 2/22 of 2012.
Yes.
Okay, at the bottom of that, does it say, have a place for Mr. or an applicant to sign?
Yes, it does, and it says, I hereby certify that the information and documentation provided as part of this application are true and accurate.
Now, if indeed Mr. Bond had answered yes to the questions that he answered no to, what would have been the next step? Would his application been automatically denied?
No, it would not have been automatically denied. We would have contacted him and asked him to fill out the application for predetermination, predecision.
And then what would have happened?
Then we would have asked him to supply the documentation that he had in regard to that. And then I would have reviewed it and Ms. Kropp would have reviewed it to make a determination whether he needed to appear before the commission. In this particular case, he would have needed to appear before the commission.
And why is that?
Because of the nature of the language that was contained in the consent order, that it would almost be tantamount to a revocation, basically saying that he could never be licensed, and so it would really be something that would be in the commission's discretion to decide.
But that didn't happen.
That did not happen, no.
Okay. And if he had answered those questions, then the application could have gone forward. There would not have been anything automatic about it. It's automatically
It would
denied.
not have been automatically disqualified.
And the commission or the regulatory board division of the real estate division, do they have absolute contact with all the divisions of the state of Tennessee with licenses? Is there a website or a reporting thing that absolutely puts out any disciplinary actions against licensees in the state of Tennessee?
There's not a database per se. There's a monthly disciplinary action report, but there's not a database where one would go and access that information
So,
easily that I'm aware of.
Are you relying on the applicants to tell the truth then in processing their applications?
Yes, we are, whether it's a felony disclosure or whether it's some sort of other disciplinary action taken by agency, we are relying on the applicant themselves to answer it truthfully and honestly.
And in all the applications, Mr. Bond said he did that, didn't he?
He said that he did when he certified that at the bottom, and there's language that says that it's failed to disclose any required information as grounds for denial or revocation of a license, and then you certify at the bottom and sign.
Thank you. I have nothing further.
Do you have any further questions for the witness, Mr. Bond?
I just have one question.
Okay.
So at the point of the application process, there are no checks to confirm any of those items that the applicant checks yes or no to. What I mean, I guess, is there background checks, anything to ensure that what they're saying, that an individual just didn't get out of jail 2 weeks prior to that and applied?
No, the screening questions.
Yes, the screening questions.
There is not. Now, we do ask if you're 18 years old. That's such a requirement, and that is verified. I mean, we verify that because the individual sends in a license or usually sends in some sort of documentation. The other questions, the screening questions, we again expect for those to be answered truthfully and honestly by the licensee, because that's what they're verifying that they will do. And that's what that's the expectation, and that's what the commission expects someone to do.
Okay.
All right. Board commission members, this is your opportunity to ask questions of the witness.
Anybody have any questions of Ms. Maxwell?
Ms. Maxwell, it hasn't been presented in the proceedings, but is there a copy of the facts that was received in the file?
There is, yes.
Do
It's
you
not part of
intend
the
to?
complaint file.
It's not.
I don't have a copy of it in the complaint file.
Okay.
Yes, everything, if I may address Mr. Northern's question. Everything
Sure.
Anything, Mr. Northern, if it was in the complaint file, you have a copy of it. So that was what in the legal file.
There was a copy of the order sent with the complaint.
I'm a little confused. If you said if it was part of the complaint, it's in the file?
If it was part of what was presented to legal as part of the complaint file, it is a part of this document here.
So it's a part of the file, but it didn't get
I-
submitted to legal?
I can't answer that.
Is that correct,
I don't.
Ms. Maxwell?
Facts cover sheet.
Oh, the facts cover sheet. Oh, the facts cover sheet is, well, the facts cover sheet was not part of the complaint. The facts cover sheet that said to Ms. Fowler, that was not submitted as part of the complaint.
Is it in the file?
It is in the file. It is in the personal file of Mr. Bond.
Okay. Would it be improper to ask where it was derived from, Judge?
The facts cover sheet?
Yes.
I think you mean the phone number?
Do you have it with you, ma'am?
Yes, I do. Yes.
And I assume you have just one copy, probably the original, I would imagine.
Yes, I do have the original. It's got a phone number at the top of the page.
Let me just ask a different question then. Did it come from the Department of Commerce and Insurance Securities Division?
No, it did not.
Okay.
It came from a 901 number.
Thank you.
The only question I have, and I don't know who to address it to, I read, and it's in the file of the Securities Exchange, and I see that there was a $20,000 fine or assessment to Mr. Bond plus court costs. Was that paid? Does anybody know whether that money was received?
That may be a question for Mr. Bond, who's going to testify later.
No.
Did you pay the $20,000?
No, I didn't. I wasn't aware of that. I
And
wasn't
you
made
didn't,
aware of
and
that.
you didn't pay the $856?
No, I wasn't made aware of that until all of this came about.
Is this
Sure.
appropriate, Your Honor?
No, Mr. Bond hasn't testified yet.
Okay, so,
So if you could save that question for his testimony, that would be better.
Thank
Thank you,
Your
Mr.
Honor.
Chairman.
Okay, well then I'm going to kind of follow up on his question. Did you, Ms. Maxwell, see if any of these fees had been paid? Was there any documentation that had been paid besides just the fact that this document was faxed to you? Was there any communication with the Department of Insurance that these fees had been paid, and if so, by whom?
I do not know whether the fees were paid. Our problem with Mr. Bond was that he didn't answer the question
Right.
truthfully, that he had a complaint that had been filed against him, and the question wasn't answered. The two questions weren't answered truthfully. And so what the final disposition of that was not really the issue with our department.
He says we got to stop.
if, we need to change out the tape. And while we're changing out that tape, these proceedings have been going on. How much time we have left on that tape? How many? Okay. Does anybody have any other questions of the witness, Ms. Maxwell?
Yeah, I just wanted, was there any other communication with the department on this besides just the fact that you got a copy of it and you didn't, was there any other communication with?
There was a email sent by Ms. Kropp just advising them that we were opening a complaint against Mr. Bond for not answering the questions truthfully.
Okay, so it was sent to the state of Tennessee?
Correct.
Commerce and Insurance. Okay.
The last page of the document that we have actually has the Tennessee Securities Division information on it, but you could find that on the internet as well.
Okay.
Any other questions of Ms. Maxwell?
If not, thank you for your testimony. This will probably be a good time to change the tape.
Yes, ma'am. Be a good time to change the tape, and we've been going an hour.
About around,
Should we take
about an hour.
Should we take a quick break?
Robin's having a fit for some reason.
And continue on?
Well, only because Mr. Cliffroft is leaving at 11.
Okay.